Supreme Court is reconvened.
Please be seated. Good morning and welcome back to the Washington Supreme Court for the second of three cases today, Tuesday, October 25th of 2022. We're here at the Cherbourg Building. Again, thank you to the Senate for allowing us the use of the building while ours is being renovated. The second case is the State of Washington versus Atiri Kevel Norman. The petitioner is the state. Opening is 15 minutes by Theodore Cropley. The response by Kyle Berti of 20 minutes and 5 minutes reserved for rebuttal. Counsel, please proceed.
Good morning, Your Honors. May it please the Court. Theodore Cropley representing petitioner of the State of Washington. After only a couple hours in the jury room, the trial court clerk heard a tremendous commotion, banging and yelling from the jury room. After abruptly adjourning, all but two of the jurors contacted the trial court to express their alarm and their fear due to the conduct and actions of juror number 9, who was repeatedly punching himself in the face. Under RCW 2.36, a trial court is required to dismiss a juror when that juror's conduct is incompatible with proper and efficient jury service. Here, after conducting a hearing, the trial court found that juror number 9's conduct was incompatible with such jury service because his conduct was intimidating to the very deliberative process. In doing so, the trial court did exactly what was required under this court's precedent in Elmore. It held a hearing to inquire into the conduct and what happened in the jury room, and after hearing this testimony, properly exercised its discretion in dismissing juror number 9 because his conduct was impeding free and open discussion and was thus incompatible with proper jury service. The Court of Appeal in this case erred when it applied a heightened evidentiary standard to the trial court's decision. That standard was improper because, as this court held in Elmore, any heightened evidentiary standard is only applicable in a rare case where that juror is accused of nullification, refusing to deliberate, or refusing to follow the law.
Do we have to decide whether there was some aspect of the juror's view of the case that was considered in the decision by the court? In other words, can we infer from these facts that there was some disagreement among the jurors and that this juror disagreed with others on the substance? Or is that really not relevant to the analysis and it's simply an abuse of discretion unless there's explicit information about the difference of views of the case?
Well, that's correct, Your Honor. In this case, the heightened evidentiary standard is not even reached unless this is one of those rare cases. And so even if the state doesn't dispute, the presiding juror did, despite the admonition of the trial court, make some mention of views on the merits of the case. But, certainly that doesn't transform this case into one of the rare cases where a heightened evidentiary standard rather than the abuse of discretion standard is required. Because again, in this case, as this court held in Elmore, this juror was not accused of nullification, not accused of refusing to deliberate, or accused of not following the law. So the standard remains under the RCW's 2.36.110, abuse of discretion standard.
So can I change let me just ask to make sure I'm clear about the rule where you're drawing the line. So if we change the facts just a little bit, and during the course of the hearing, talking to multiple jurors, the court learns that the juror sought to be excused was clearly a holdout, that everybody disagreed, but there's no allegation, nullification, refusal to deliberate, refusal to follow the law, but they're clearly a holdout. What then?
Well, Your Honor, again, under this court's precedent in Elmore, the rare case standard would still not apply. However, that would go to the trial courts, whether the trial court abused its discretion or not. Here, of course, as you recognize, Justice Stevens, that's slightly different than the facts that we have here. But even under a case where it's clear that a juror is a holdout, if the trial court finds that the conduct of that juror, not his or her views on the merits of the case, but the conduct, and here the conduct was repeatedly punching himself in the face. If that was disruptive, if that was chilling the deliberative process, and that was thus therefore incompatible with proper jury service, the trial court does have the discretion under the abuse of discretion standard to dismiss that juror. And so certainly other judicial officers could have made a different call in this case, could have sent the jury back in to give it another try. But
Wasn't mistrial also another alternative, or would that have been premature?
I'm sorry, Your Honor.
I apologize for the mask. You said the alternatives were dismiss the juror or send them back to try again. Isn't mistrial another alternative?
Well, possibly, Your Honor, in the sense that if the trial court, in its discretion, found that maybe the jury had been, tainted by certain evidence or by, certain what had happened in the jury room, I don't think there was any evidence of that in this case. So again, that would be another discretionary call.
Well, we're dealing with a new hypothetical that Justice Stevens put forward.
Certainly.
And it tests the limits of the rule that you're asking us to apply, and when it's an abuse of discretion standard. And so if the one holdout juror says, you, the rest of you, agree with me, or I'm not going to punch myself, I'm going to punch you. And if that's the evidence before the judge, same result, dismiss that juror and bring in an alternate, or something else?
Well, again, under the abuse of discretion standard, that would be up to the judge. The judge is in the trial court judge is in the best position to evaluate what happened. Heard from the other jurors, heard from the court clerk about what the jurors had reported. And so given the specific factual circumstances before that trial court judge, it is the trial court judge who is in the best position to decide how to go forward, to declare a mistrial, to replace this juror, to give the jurors another shot. And again, depending on the circumstances, different trial court judges may make different calls. But certainly given in this particular case, given what was in front of the trial court judge, based on what it heard from the jurors, what it heard from the clerk, it cannot be said to be an abuse of discretion in this case for the trial court to replace juror number 9.
Yeah, I was a lower court judge for many years, and I can't remember ever having this sort of situation come up before. And so I guess my question is, could the judge, is it within the judge's discretion if she had just sent him back and said, stop punching your face and go back and deliberate a little longer? Would that have been okay?
Yes, that would have been. And again, I think possibly other trial court judges may have made that call to try again, because certainly some of the other jurors, I think the other jurors that testified were willing to give it kind of another shot. And so that's within the trial court's discretion. But here, faced with what the trial court had in front of it, and again, under the RCW's, the requirement to dismiss this juror if the judge finds that the conduct is incompatible with proper and efficient jury service, it cannot be an abuse of discretion in this case for the judge to have made the call to dismiss this particular juror.
Does it make any difference if there are alternates and you don't actually know who's going to be on the jury? Say there are 14 people there, and until the end of the case, you don't know who's actually a juror. Well, I guess we're beyond that. Never mind.
Yeah, I think in this case, Your Honor, there were actually the 12 that were in the room. Yes, and so the cases cited by Mr. Norman in the briefing are all distinguishable from what happened in this particular case. In Benyard, the trial court actually failed to follow the proper procedures. In Johnson, the court used the standard in Elmore that the Court of Appeals used that was subsequently changed by this court. And in the Michigan case, Cadell, that case did not involve self-harm, only the discomfort of the jurors here. And what we have in this case goes far beyond any discomfort from the jurors. So it can be even, certainly argued that some kind of discomfort is actually welcome in a deliberative process when 12 people are trying to come to a unanimous decision. But what happened in this case went far beyond that. It was a juror that was actually punching himself in the face, causing fear and concern, if not for themselves, at least for this particular juror, which the trial court found had to be, had to have some kind of chilling effect on the process. These jurors didn't know what would set this juror off. And so this free and open debate that's necessary in a jury deliberation process was chilled in this particular case.
Can I ask you, though, about, the RCW speaks in terms of behavior incompatible with efficient jury service. And people have different levels of tolerance for robust debate or disagreement. And so it may be that someone on the jury has a higher tolerance than others, but it's not as dramatic as this sort of case. So if under the test you propose, the court doesn't need to start with a higher level of resistance to dismissing a juror, when I think the argument is when the court comes to know, however that occurs, that that some of the behavior was due to the fact that the person had a different view from other jurors. My concern is, how do we then protect against the risk that, human beings are going to have different levels of engagement, and we're essentially culling out the holdouts? That's one of the, I forget which case uses that phrase. We don't want to cull the holdouts. How do you think this test actually protects against that? Because any number of behaviors may be incompatible with sort of the dominant theme in the room, but it's still a process in which people are going to disagree, and sometimes fairly strongly during the course of deliberations.
Yes, Your Honor, and I think as a policy rationale, that's a good thing, that people disagree or that people are engaged. And sometimes the debate can be, I imagine, pretty fiery. Where the line, though, is when harm occurs, physical harm occurs, whether that's a juror causing harm to him or herself or threatening harm to others. One of the primary, one of the top considerations for a trial court judge during jury deliberations has to be the safety of the jurors. And so there is a difference between robust debate, even strong disagreements, and physical violence. And what we have here is physical violence. It's self-violence, but it's physical violence nonetheless that caused a great deal of alarm and concern and fear in almost every single juror in this case. And so where that line has to be drawn, certainly self-harm, physical violence is on the side of the line where it's within the trial court's discretion to dismiss that juror because that conduct is incompatible with jury service.
Why are you drawing the line at physical harm?
Well, not necessarily drawing the line, but wherever that line is drawn, physical harm is on one side of the line. And so I think that, certainly the trial court in its discretion, given the circumstances in a particular case, being in the best suited position to understand the situation, gets to set that line. Between let's give them another chance, this is maybe heated disagreement, versus no, there's a real safety concern here. There's a real danger here. And so certainly in this case, again, I wouldn't argue that some judges may have made a different call, but it cannot be that there was an abuse of discretion in this case.
What about if a judge, let's say 11 jurors come out and say, juror number 12 is a bully? No threats or anything, but just really obnoxious, really pushy. Mm-hmm. Does the court have discretion to say no bullying in the jury room?
Well, under this court's precedent, it would have to hold a hearing first to find out, not the merits of the case, not the jurors' views on the evidence here, but what actually was going on in there. What does it mean to be a bully? If that.
And I guess that's exactly what my question is getting to, because we're starting here with a just simple statement in a statute, but we have, an inviolate right to a jury trial and a lot of things in here in the verdict, including bad human behavior during the course of deliberations.
Absolutely.
So what prevents the judge from just having open discretion to, be the classroom monitor?
Well, in a sense, the judge is in the position, I wouldn't say classroom monitor, but the monitor to make sure that the deliberation process is working. As messy as that can be, the judge is in that position. So, bullying, what that means, it could mean different things to different people. But the judge would have to ferret out, what actually was going on conduct-wise in the jury room and make the decision on whether the bullying juror or whoever the juror complained of is his conduct, his or her conduct, is actually chilling the deliberation process, is actually incompatible with jury service. And again, maybe not. Maybe in a particular case, it is just kind of a robust debate. But other cases, certainly, that fall on the side of the line where this case does, the trial court is within its discretion to, under the RCWs, to dismiss the particular juror. So with the court's permission, I'll leave the remainder of my time for rebuttal. Thank you.
Thank you. Response, please.
Good morning, Your Honors. May it please the court, Kyle Berti for the respondent, Atir Norman. Mr. Norman asked his court to affirm Division I's holding that it was the court properly interpreted the heightened evidentiary standard, properly applied it, and regardless of that, under DePause, in the misconduct language this court articulated, the conviction still, the determination to dismiss the deliberating juror was still abuse of discretion. I really want to focus on the scope of the heightened evidentiary standard. Right? The rule itself is in possibilities. I think a couple of the questions allude to needing actual. Do we actually need, the person to be accused of being a holdout? The Thomas court kind of explains this, is how that is interpreted, how that misconduct or those allegations come across from the jury are going to be different. One juror might say that person is a holdout. Another person say that person just won't change their mind, right? And so that accusation, we don't need the actual part of it, right? So to get to the rule.
I agree with you that there's going to be difficult lines to draw, and we don't want, I don't want she's obnoxious or he's obnoxious to be the standard. But where there's physical violence going on in the jury room, and the jurors accuse one particular juror of engaging in physical violence, then they're not accusing that juror of refusing to follow the law or refusing to engage in deliberations. And isn't refusal to follow the law the prerequisite to applying the heightened standard?
In two parts. So, no. The standard, the test to determine whether or not the heightened standard applies is whether there's a reasonable possibility that the impetus for the juror's removal stems from that juror's thoughts on the sufficiency of the evidence and their ability to communicate. And that goes back through Symington, Thomas, Brown. Now, in terms of the physical violence portion.
I think that was an if-then statement from Elmore, or a where-then statement. Where a deliberating juror is accused of refusing to follow the law, that juror cannot be dismissed when there is any reasonable possibility that his or her views stem from an evaluation of the sufficiency of the evidence. So, I used to be in trial courts. It seems to me that this juror's, what happened probably stemmed from a discussion of the evidence. But I don't see how the other jurors were accusing the violent juror of refusing to follow the law. My read is that deliberations abruptly ended, and they decided to end early for the day. And when jurors were asked, they said, he's hitting himself.
Well, they said both. So the initial report from court staff from the presiding juror that next morning, the first thing that person said was, the presiding juror has accused juror number 9 of not being open-minded. Right, that was the language. Right there, we're on notice that there's some sort of kind of holdout nullification, refuse and follow up, where it's indicative of those kind of traits that this court has said the heightened standard applies to. And then that is confirmed. Juror number 9 says, yes, we had a disagreement about the merits of the case. We had a disagreement, and I had a position, and those jurors had a position different from me, and it got heated, and I felt attacked. Thomas, I rely on Thomas a lot, and I think it's because there's that interaction there where it's not going to come across necessarily as they are a holdout. And I think this court's...
I get that.
Yeah.
I get the danger of, I get the danger that you're talking about. But if this juror, as some other justices posited in hypotheticals, if this juror got so upset and started hitting the juror next to them because, and it stemmed from feeling like they were a holdout, do they get to stay on the jury?
No. And I think Abel and Edwards make that abundantly clear. And it's because the purpose of the heightened standard is to protect the process of the jury, right? That's why the first instruction is send the jury back. Let this process happen organically. Now the court and the parties are on notice that there may be an issue with a holdout juror. So misconduct can still overcome this presumption of fitness. And just to be really clear about the self-harm, the emotional outburst, Justice Montoya-Lewis, this is something you brought up. It's not just self-harm, it's emotional outburst from a result of differences on the merits. He punched himself supposedly twice, not repeatedly. It wasn't, oh my goodness, he's running around kicking and screaming. I felt attacked, I felt overwhelmed, and I hit myself. And the only thing we have to go on is he hit himself twice. So this idea that just that self-harm himself is disrupting the process, there's two instances. I mean, that's no different than banging your fist on the desk in frustration because you can't. I don't see that as being going to the extent where it's being a bully situation. Justice Stevens, I think under that bully kind of hypothetical, right, that goes against the process or against the purpose of the heightened evidentiary standard, right? It undermines the process itself. When you start having a bully, I think there's a jury instruction in the WIPICs, maybe it's 104, but you have a duty to talk to each other. You have a duty to work things out. When you start implicating the bulliness aspect to it, that kind of goes against that grain.
Counsel, I just have to clarify this. Are you suggesting that pounding on a table and punching your face are the same, that there's no difference?
I really don't think there is, because it's an emotional outburst. It's not I'm going to punch you because I feel attacked, right? That is categorically different. But when juror number 9 says, I felt overwhelmed, we were in heated discussions, I felt attacked, I'm not a doctor, so I don't know how to categorize, medically what that means in terms of 2 punches of self-harm.
Right, but do you really think we're talking about a medical diagnosis? You don't think that somebody punching themselves influences anybody else who sees that?
No, I don't, because they're their own independent person. Why does that juror who voices their opinion and their thoughts on the case, and the juror number 9 voices their thoughts and opinion on the case, acts a certain way, and the challenged jurors say, well, I voiced my opinion. I don't like how he responded to it. So can you remove him, right? It's going to influence me. You're your own person. You've been told by the judge, make your decision based on your review of the case. Listen to your jurors and talk it out. Let this process happen organically. So I see this as kind of a mixed question where, does it have a chilling and open, I think the judge said, this surely has an intimidating feel to it, and it's chilling, free and open debate. The jurors didn't say that. The jurors initially, to the court staff, said, well, it makes me feel uncomfortable. But then when the judge asked them about it, they said, well, it doesn't make me feel uncomfortable. I'm okay. I can still render a fair decision. Maybe it's someone else, right? So at that point now, the only record we have is a supposed complaint that 2 punches and an outburst, and we don't have any more than it was 2 punches to the head, to say, oh, because I'm uncomfortable, let's remove him. We just don't have any more information. And that gets to, kind of the process here. I think this.
Counsel?
Yes.
I'd like to go back to how you view the pounding on the table and the hitting of the individual hitting themselves. Because until you made the argument, I really didn't see it, but now I'm seeing what you're trying to say. My question is, where do we draw the line in regards to behavior that can affect or may affect the process? Are you saying the trial court judge should have interviewed independently all of the jurors? Because we do only have a few in the record that were interviewed, and we have to, I guess, infer or surmise their perception, because like you indicated, you're not a doctor, of what they observe. Is that what you're saying in a situation like this, where the trial judge is supposed to interview all of the jurors to get an accurate feel or understanding of what actually occurred?
No, I don't think so. And the standard, once the court became aware that this juror wasn't being open-minded, and juror number 9 said, we're having disagreements about the merits of the case, I think that's where the heightened standard triggers. And then we just look at, we ask the trial court, please apply this standard, right? Keep in mind the various constitutional rights at play. So there needs to be enough investigation, but that's why it's any reasonable possibility for the impetus for removal. So we don't want to investigate too deeply. This is the original purpose of the standard, was to say, once you start investigating too deeply, both parties have a right to a fair and impartial trial or jury. So when you start questioning that and exposing that, you destroy jury secrecy and deliberation process. So no, not too deep, but the heightened standard already turned on, right? It already triggered once that judge and the parties were aware that the impetus for the punch, the challenge, the request for removal stems from that juror's views on the case.
Can I ask you this question as a follow-up? Because I wonder how much the heightened standard is really the focus of the disagreement in this case. Because in some of the cases where the court finds error and abuse of discretion by the trial court, there was no further inquiry. They didn't hold a hearing. They didn't talk to a lot of jurors. But here the court did. So the court became aware during the course of several people speaking that the merits were at least in play here, that we know juror number 9 disagreed and was accused of not being open-minded, et cetera. But once that is assessed and the court makes a determination on the record that this behavior crosses a line into conduct that is interfering with, it's incompatible with jury service or interfering with efficient jury service, how is an appellate court in a better position to second-guess that? And what rule of law would you have us adopt? Because it seems like the variations are endless, and the trial court's got to be in the best position to make a fair call.
So Abel and Edwards, 2 federal cases, acknowledge this. So in terms of how the process is, right? And I think DePaz mentions this, and maybe even Elmore. Once the standard is applied, then we review for abuse of discretion. And so Edwards and Abel apply a different standard, but those cases acknowledge that if the judge applies that standard, right, applies a higher evidentiary standard, then we're going to review that for abuse of discretion. And then we're going to look at is the judge's determination supported by the record or, for untenable reasons? So I think Elmore and DePaz continue that. If the trial court applies the heightened evidentiary standard through that process and follows the process described in Elmore of conducting a balanced investigation, but not going too deeply, and then send them back. I mean, that's, again, the reason why the opinions keep saying, send them back. Let it happen organically. Monitor it. Now we know. Just let them do their thing. There's a variety of WIPICs and criminal rules, I think 6.15, just don't say too much. Just let the jury do their process.
So what would have happened in your mind if juror number 9 had punched himself in the face in the courtroom while evidence was being heard?
I think then, it will depend, right, what the trial court actually finds. But then that gets to the purpose of this heightened standard is to protect the process. The cases that discuss incapacitation or unavailability, Thomas, I think Brown cites a few cases as that well. Even if this were to trigger the heightened standard, how does that affect the jury's ability to evaluate the evidence? Is there going to be a long gap? Are they going to be able to recall witness statements? So in terms of if they're actually deliberating, they're in the deliberating phase, there potentially could be, the judge could still dismiss that juror, but the heightened standard still has to apply. The process still has to be followed. And then, as this court said, we applied the abuse of discretion standard.
So going back to Justice Yu's question about whether or not punching oneself or the table is so disruptive that the juror needs to be removed, I'm wondering about a juror who does that, who then causes distress in another juror because that juror has had some sort of traumatic event where that behavior makes them so uncomfortable that they're unable to focus. Or it's a domestic violence case, and this juror engages in some behavior that, because it's a domestic violence case, perhaps makes others in the room, having heard evidence about what domestic violence is, feel like they're being intimidated, or that juror is attempting to intimidate them. How do you craft a rule that that fairly addresses the issues of the ability of a jury to deliberate? You've used the word organically a number of times, so deliberate organically, and also preserves the defendant's right to a fair trial. How do you create a rule that fairly addresses all of those concerns?
I mean, this court already did craft that rule, and that's the reasonable possibility standard. And this court has said it in Elmore, said it in DePaz. The Court of Appeals has recognized it, Johnson, Bernard, and now in Norman, that if there's a reasonable possibility that the impetus for removal stems from that juror's views, so on and so forth, right? That itself, the test, balances the constitutional rights and the trial court's need to investigate and address issues of misconduct, which is a repeated thing since Elmore, especially during oral arguments. This has been the repeated issues. How far do we let the trial court go? So the rule's already there. Once the standard is applied, then we review for abuse of discretion.
So you're not really asking us to do anything except, is that correct?
Yes. My apologies, yes. I'm not. Division I in this case recognized a principle that stems from Elmore and then goes through Johnson and Bernard and that is emotional distress that stems from that juror's views on the merits of the case, the sufficiency or their ability to communicate their thoughts, if it indicates that they're a holdout or a nullifier refusing to apply the law, they're a protected juror. The heightened standard applies, and then we review for abuse of discretion. We never got there, right? As everyone's kind of agreed in terms of the procedural facts here, there was the incident, the jury themselves called it a day, right? The court staff were very surprised. I think the court, one of the staff members was walking to get coffee or a snack or something, had to run back, right? So the jury themselves called the break. And then there was no other deliberations. Under Elmore, DePause, all these cases, just, we know what's going on. We know that there's disagreements about the merits of the case. The heightened standard applies. Just send them back. And now we know, we can see. If the conduct continues, right, if he's still punching himself in the face, maybe, he had a plan. He said, I'm going to take breaks. I'm going to ask for breaks. I know what I'm going to, I'm going to do. I've experienced this before. This isn't a new phenomenon, right? Let that happen. Maybe there's too many breaks. Maybe he's got to call his therapist and it takes 2 hours. Then at that point, the trial court can say, okay, look, now the process is being undermined. I understand you're a holdout juror. I recognize that, but you're undermining the process of the jury to deliberate. So with that, Mr. Norman asks this court to affirm Division 1. Thank you.
Thank you, counsel. Rebuttal, please.
It appears that counsel is confusing what the heightened evidentiary standard is with when that is applied. The heightened evidentiary standard, which holds that where there's a reasonable possibility that a juror's dismissal was due to his or her views on the merits of the case, that only applies in the rare case where this court has set forth in Elmore. It's the way counsel has phrased it, it's like the evidentiary standard perpetuates the evidentiary standard. But no, that standard, because it's a harsh standard, that, a juror who's, where there's a reasonable possibility that the juror has certain views of a case, cannot be dismissed. Since that is a pretty high standard, this court in Elmore restricted that standard specifically and explicitly to the rare cases, which this case is not.
Can I ask you to articulate, because each of these cases evolves on its own facts. So what's the justification for limiting that reasonable possibility consideration to nullification, refusal to deliberate, or refusal to follow the law, as opposed to jurors radically differing views on either the law or the sufficiency of the evidence under the law?
Well, I would speculate, Your Honor, that in Elmore, this court restricted the evidentiary standard to those cases because it was in those types of cases where it would most likely call into play a juror's view on the merits. Nullification, perhaps thinking that, even though this law is on the books, it shouldn't be applied or shouldn't be followed here. Refusing to engage in deliberations by just, sitting back or, actively not following the law.
Could it be that those three instances were the examples of juror misconduct that were identified and therefore then needed to be considered alongside whether there's a reasonable possibility that that misconduct was actually due to the juror's view of the sufficiency of the evidence? Do you see what I'm getting at?
I do, Your Honor, and I would disagree only because the words in Elmore itself seem to disagree. The opinion itself that does state that we also emphasize that this standard is applicable only in the rare case where a juror is accused of engaging in nullification, refusing to deliberate, or refusing to follow the law.
So and I'm just trying to get at why would we say that? So you're saying the rule would be that if the evidence is the juror is threatening physical harm to others, but not doing one of those things, no heightened test?
I would agree, Your Honor, that the heightened test, again, applies in those situations. And the reason being that in a case like this, where the juror is not accused of doing one of these three things, then, what is this juror doing? If the juror is not engaged in one of these three types of rare activities, then what is the jury accused of? And it would be a case like this, where the jury is accused of something like self-harm. And the test, therefore, it cannot be, well, let's just send them back in, hope for the best, maybe put other jurors at risk, but let's hope for the best, despite this demonstrated self-violence. That cannot be the test here, because smacking oneself, punching oneself in the face is different than banging on the table.
I agree with you on that, but your answer, I wonder what you would think of a standard. The standard you're enunciating would say that you could complain about the juror because they're a jerk, and get them knocked off, because the heightened standard only applies in certain rare cases. And so being a jerk might have nothing to do with the evidence, but let's get them kicked off because of that.
Well, there's still a standard, Your Honor, and that's the abuse of discretion standard for the court. So maybe a juror doesn't like another juror and thinks he or she is a jerk. No, then it's in the discretion of the trial court judge, who's in the best position to evaluate what's happened. And is it just because these jurors don't like each other? That's certainly not enough. And so in this particular case, as I see I have a few seconds left, there's also the policy considerations. Jurors, it's kind of well-known, jurors, people may not like to serve on a jury. This will certainly exacerbate that problem if jurors know that the deliberation process may involve certain violence. And if I just have a moment to wrap it up, Your Honor.
You may summarize the relief you request.
Yes, Your Honor. So the state is asking that this court reverse the Court of Appeal and affirm the conviction of Mr. Norman as the trial court properly exercises discretion in dismissing juror number 9. Thank you.
Thank you to both counsel for your briefing and argument. The case is submitted. We're in recess until noon. We'll be swearing in some new attorneys to the bar. We are in recess.
All right. Supreme Court is in recess.